Thanks very much, Kate, and good morning, everyone. So, growing an agritourism business when you don't own the land, which of course you don't if you're an agricultural tenant or a crofter. So, I'm not going to tell you how to grow an agritourism business because that's something you know about and I know next to nothing about. But what I can tell you about are the legal constraints that an agricultural tenant or a crofter has, which an owner-occupier doesn't have. So tenants and crofters have additional challenges to growing an agritourism business as compared to somebody who's an owner in their own right. So a little technical fail here. The screen has stuck. Any help? Okay.
The technical development guys at the back here, it should just play through.
Yeah, I think the space bar was working yesterday. No.
Do you want to have a wee look? Thank you. Other than turning it on and off again, gets a bit lonely.
There we go.
Smashing. Thank you.
Thank goodness for a young person there. So, moving on, what I'm going to do is speak about what the legal rights of agricultural tenants and crofters in relation to agritourism activities are. I was looking, when I was putting the slides together, I was looking on my phone for photos that might vaguely relate to agritourism in Scotland, and I have to confess that I couldn't find any, so I've just put up a nice scenic picture. I've got one to finish my presentation at the end of the talk. There is a prize for anybody who can tell me where that is and where the next picture is from. So, I'm going to begin my discussion this morning by looking at agricultural tenancies. I'm going to say something about the statutory framework, where you can find the law about this, what the procedure is, how not to do it, and some lessons that we can learn from a recent land court case about diversification. Diversification, we all pretty much vaguely know what diversification is. When it's used in this context, it means carrying on a non-agricultural activity on the farm. Now, prior to the coming into force of the Agricultural Holding Scotland Act 2003, agricultural tenants didn't have a legal right to carry on a non-agricultural activity on the tenanted farm and ran the risk of being found to be in breach of their obligations as tenant under the lease, and in serious situations that might even have led to the tenancy itself being jeopardised. And it used to be the case, for example, that even a relatively modest bed and breakfast business might be prohibited by the landlord, and there was nothing essentially that the tenant could do about that. So the Agricultural Holdings Scotland Act 2003 changed that. The law can be found in Part 3, Sections 39 to 42. You don't have to read those sections, and I'm going to tell you, broadly speaking, what's in them. Essentially, what the Act does is allow an agricultural tenant farmer, and that could be a secure tenant under an old-fashioned traditional tenancy, or it might be a tenant under one of the new forms of fixed duration tenancy. It allows that tenant to serve a diversification notice on their landlord. So what the diversification notice does is set out what the diversified activity is going to be. It's going to explain how the business is going to be financed and managed. It's going to say where the diversified activity is going to take place, whether it involves land or land and buildings. It's also going to specify what changes are going to be made to the land and buildings to facilitate the agritourism activity. And it's also got to set out why that activity won't be materially prejudicial to the landlord's interests. It's not detrimental to the amenity of the estate. It won't cause the landlord hardship. it won't mean that the part of the tenancy being used for the diversified activity can't ever be used for agriculture in the future if the diversified activity stops. So there's quite a lot has to go into that notice, and it's another part of the process that you as a tenant will have to consider when you've got your business idea, you're working out how you're going to fund it, you're working out how you're going to manage it. You also need to think, well, I also need to serve a formal notice on my landlord. That notice has to be served at least 70 days in advance of the activity itself starting, and the landlord has an opportunity to either object or to consent, but impose conditions on how the activity will take place. If the landlord simply objects, then it's up to the landlord then to apply to the land court for an order upholding the objection. So the onus is on the landlord to do something about it if they're just flat out objecting to the diversification taking place. If the landlord says, fine, but I want to impose these conditions on the activity, it's then for the tenant to make an application to the land court to change or lift those conditions completely. Now, the land court can do that, or the land court can impose reasonable conditions that it thinks should be in place. So, how not to do it? Well, you need to serve a diversification notice in the first place. Lessons to be learned from a recent land court case. There was a case in Aberdeenshire not so long ago. A tenant farmer had established a diversified business. That business had been established well before the 2003 Act came into place. And it was a conservatory and double glazing business. And the tenant was really, really good at it. And it was a very successful business with a very strong turnover, so much so that the tenant converted the business into a limited company, made renovations and so on to the buildings on the farm, a workshop, a sales room, and so on. And gradually, the business became the dominant economic activity on the tenanted farm. Now, the tenant essentially had stopped farming. Now, he was dressing up various arrangements, sublets, the land court eventually found. He was letting out his grazing, he was letting out the cropping land and so on, but he was dressing up the paperwork to look as if it was a series of contract arrangements and so on. And the land court said, well, that wasn't what was happening. He was subletting, and he was essentially he'd stopped farming. The end result of that was that he lost the protection of the Agricultural Holdings Act and eventually lost the tenancy completely, and the landlord obtained vacant possession of the farm. Now, the tenant in that case ran a couple of arguments. One of them was that he was entitled to carry on the business via a limited company, and the land court said no, that wasn't what the legislation entitled the tenant to do. The tenant had to manage and finance the business using their own skills and with their own financial resources. The other thing that the tenant did there was serve a diversification notice in an attempt to retrospectively, as it were, push his business activity through the diversification procedure. And the land court said, no, you're not allowed to do that either. You can only use the diversification procedure under the Act in relation to a diversified activity that you haven't actually started yet. You can't use the diversification procedure to cure an existing activity which you didn't have consent for in the first place. So, I'll go on to chat about the commercial lease as an alternative. So, there are situations where the tenant might have a very good business idea, but needs a partner or a financial backer to help make it work. and might want to pursue it via the vehicle of a limited company to protect against unlimited liability if the business goes belly up and so on. One alternative then is to agree with the landlord that whatever is needed for the diversified activity is taken out of the agricultural lease and then let back to the tenant in a standard commercial lease. So the landlord lets on a commercial basis land or buildings that the tenant or the tenant's limited company, in which he's got financial partners with him, takes a commercial lease, pays a rent, uses the buildings or the land, which is fine, and it does make a lot of sense, especially where the tenant, the agricultural tenant, doesn't have security of tenure. But in my opinion, fully secure agricultural tenants should be wary of that option. The reason it should be wary is that it does involve taking out of the secure agricultural tenancy a chunk of land or buildings. They'll be let back to them, but for a finite period of time. Now, it doesn't matter if it's 10 or 15 or 20 or even 30 years. That will come to an end at some stage in the future, and those buildings, that land, might be permanently out of the agricultural tenancy. So that's something that secure agricultural tenants in particular should be wary of, because of course, all things being equal, a secure agricultural tenancy has the theoretical possibility of lasting for as long as the tenant and the tenant's family want it to. The tenant has security of tenure for as long as they want to have it. They've also got the ability to pass the tenancy on to a family member, either during lifetime when they retire or after death. And there is no limit of succeeding generations who are able to inherit a secure tenancy. So giving up a substantial part or even any part of the tenancy to pursue an agritourism activity, which inevitably is going to be for a fixed period of time in some sort of leasing arrangement from the landlord, has to be something that has to be thought about very carefully. Because if the tenant can achieve that using the diversified procedures, then they will always have occupation of that land or those buildings. So, in a perfect world, of course, everybody served a diversification notice post-2003. They've gone through the procedures. They're absolutely protected by statute. But in the real world, there are a lot of diversification activities out there which began before 2003, or they may have begun since 2003, but without the procedures having been followed, and rely on informal or formal consent from the landlord. Now, of course, if you began your activity before 2003, we now know from the Land Court case that I mentioned earlier that you can't use the diversification procedures to cure that. So in order for the tenant to be safe and secure in that enterprise, they do need the agreement of the landlord. And ideally, they want a formal written agreement where the landlord consents to that activity taking place throughout the lifetime of the tenancy, no matter how long that lasts. If there's nothing in writing, then the tenant is vulnerable to the landlord at some stage changing their mind. So the landlord says, well, I've been happy for you up to now to carry on that activity, but actually it doesn't suit me anymore and I want you to stop. That's what brought things to a head in that Aberdeenshire case that I mentioned. And without a formal agreement allowing the tenant to continue that activity, the tenant doesn't have anywhere to go. They've got to stop. So, and it may be that the existing landlord would never do that in a million years, but landlords change. The next generation inherits who might have a very different outlook on things. So formal agreement in those situations would be by far and away the best way to proceed. The worst case scenario is as I've described. The landlord says you've got to stop, in which case the tenant has to stop, because if they don't, they jeopardise the existence of the tenancy itself. Now, the way around that, I suppose, is that the tenant stops and then serves a diversification notice. But what that's going to mean is that there's going to be a complete interruption to whatever that business was, because the tenant can't continue to use the farm for that agritourism business. They've got to serve a notice and a 70-day notice period. If the landlord objects and goes to the land court, the tenant might be tied up in a dispute which might last 12, 18 months, 24 months in a worst case scenario, incurring professional fees as they go along to try and resolve it. Throughout which they're not earning anything at all from their agritourism business because it's had to stop. So you don't want to be in that position. So subletting in the context of diversification, generally speaking, it's possible, but only in very limited circumstances. The Land Court have said that subletting is permissible if it's ancillary to the diversified purpose itself. And the example that the Land Court gave was an agricultural tenant decides to establish a golf driving range, and in the corner of one of the steadings, they want to set up a shop, and they're going to let that shop to a golf professional. The Land Court said that's fine. That would be ancillary to the diversified purpose. What the Land Court said very clearly was that you can't let out your surplus cottages in the tenancy under private residential tenancies using the diversified procedures. That is not diversification for the purposes of the Act. Whereas holiday lettings are fine. So you can pursue your holiday letting business and your surplus cottages by using the diversified procedures. So, where does the farm rent go if you've actually established a successful agritourism business? So the diversified activity is something that you're entitled, or the landlord is entitled to take into account for the purposes of setting the rent. And of course, the tenant's not rented on their own investment. You're not rented on your own improvements, but what the landlord is entitled to get is a return, if you like, on the opportunity that the tenant is utilising to use the landlord's land or buildings for some non-agricultural purpose. So I'm not a valuer, and it's no use asking me, well, what would that actually look like in pounds, shillings and pence, but it is a relevant factor in a rent review. Oddly enough, if there is a rent review and you've got an informal diversification taking place because it's a pre-2003 diversification, or you've established it since then but you've not gone through the formal procedures, but that is a distinct factor taken into account in the rent review, and there's an element attributed to the diversified activity in calculating what the new rent will be. That implicitly means that the landlord is consenting to the diversified activity, so there will be a degree of protection that you'll get from that. I sometimes come across situations where the landlord or their agent is arguing that there's an element of the farm rent that has to take into account the hypothetical possibility of diversification on the let farm, even if there's no diversification taking place whatsoever. That, in my opinion, is bogus. I can't see that you should be rented on something that is a theoretical possibility and not actually happening. Unless, of course, every single farm in the district that you're situated has a diversified sideline of some sort going on, and therefore a hypothetical incoming tenant would be very likely to pursue something. But otherwise, you can't be rented on the fact that you've not actually had an idea to diversify. Compensation for improvements. You are entitled to compensation at the end of the tenancy for the investment that you've made in establishing the agritourism business. What the Act says is that the compensation is such compensation as fairly represents the value of the use, change or carrying out of the activities to an incoming tenant. So that's a hypothetical incoming tenant. Doesn't matter what's happening to the farm after your tenancy comes to an end, whether it's going to be let out, taken back in hand, planted in trees, whatever's going to happen to it. For the purposes of calculating compensation, the law says that you imagine a hypothetical incoming tenant. Will they derive a value from that agritourism business? If the answer is yes, then there will be a sum of compensation to be calculated. However, and crucially, you're only entitled to compensation if you've gone through the formal diversification procedures under the Act. So if you've got pre-established diversification from before 2003, you're not entitled to statutory compensation unless you can come to some sort of voluntary agreement with your landlord. Likewise, if you've got a diversification taking place post-2003, but you've not gone through the procedures under the Act, you're not going to get compensation for that either. Likewise, you're not going to get compensation if the fixed equipment on the farm or the land that you've used is no longer suitable for agricultural use. So if whatever you've done has essentially sterilised that building or the land from use for agricultural purposes in the future, you're not going to get compensation for it either. So these are all things that you need to take into account. So, moving on from agricultural tenancies and a quick look at crofting, the statutory regime in relation to pursuing agritourism businesses in a crofting context is actually much kinder to crofters than to agricultural tenancy. We've heard how agricultural tenants are constrained by the legislation. Crofting, much less so. A crofter, whether they're an owner-occupier or a crofting tenant, has a statutory duty to cultivate the croft or put it to another purposeful use. Now clearly an agritourism activity is another purposeful use, so that's fine. If you're a crofting tenant, however, that other purposeful use requires consent from the landlord, and if the landlord's consent isn't forthcoming, the crofter would then go to the Crofting Commission for consent. If the crofter is an owner-occupier because they bought the croft, but it's still subject to crofting tenure, then they don't require permission for another purposeful use. But of course, they are still bound by the crofting legislation. If you're the crofting tenant and you're subletting, you can only sublet subject to the Commission's consent, and any consent granted by the Commission will only be for a period of 10 years. If you're an owner-occupied crofter and you're considering a major investment on the croft, then you might also consider whether it would be best to decroft the croft and get away from the constraints of the crofting legislation altogether, because that means that the land that will entirely belong to you, it won't be subject to crofting legislation and subject to planning legislation and all the rest of it. You're pretty much free to do with it what you want. You can enter into joint ventures with financial partners to help finance major projects and so on. So that brings me to the end of my remarks. That's the final scenic picture I was telling you about. I'll be very impressed if anybody can tell me where that is at the end of the talk, and I'm now able to, very happy to answer any questions.
It would just be actually interesting, I know there's not a huge amount of us in the room, how many are in the room that are farmers or crofters at the moment? Okay, so we've got any industry professionals, there's well here? Okay, great, that's fine. So we'll cover some of your questions if you have any, but we're going to bring in some of the ones that, some really valid points were brought up yesterday that will definitely be of use.
So the situation that you're describing, if you're approaching a neighbouring landowner looking to take a tenancy over land, that won't be an agricultural tenancy because an agricultural tenancy is defined by the law as being a tenancy over land which is being used for the purposes of an agricultural business. So that includes obvious things like growing crops and livestock husbandry and so on. So where your whole purpose is nothing to do with agriculture and is the further development of your business, what you will get if you can find a landlord who will agree is just a straightforward commercial lease of the land subject to terms and conditions, a rent, a period of time in which the lease will exist and so on. So it falls out with the context of the things that I've been talking about this morning. But good luck. Oh, sorry. Well, you go back to the first one. What have I done?
Is it? No. Just touch screen.
Don't know. That one? No, nowhere near Conway. That is, that's on the top of Ailith Hill, looking north into the Angus Glens. Early July 2022, at about 10 o'clock at night. They might want to limit its scope, for example. If the diversification activity was establishing a farm shop, they might want to restrict the products that are sold in the farm shop. I've seen that on occasion, that the tenant won't, for example, apply for a liquor licence or will only sell produce from the farm and so on. So those are conditions that a tenant would have to consider carefully, because they would obviously limit the scope of the business. If suddenly things take off and you think, well, it's great, I can pursue all of these lines in the shop, but you're subject to a condition from the landlord which you haven't challenged, then you're going to be stuck with that unless you can renegotiate with the landlord, which you might be able to do, but it's likely to be expensive. So every case turns on its own facts and circumstances. Conditions that the landlord wants to impose might be reasonable, but they might not, and if they're not, then unfortunately, unless the tenant can negotiate with the landlord to relax or release the conditions altogether, the tenant will have to go to the land court and pursue persuade the land court that the conditions aren't appropriate. That's fine. Yes, I mean, I haven't personally dealt with a case like that, but I can certainly see those circumstances arising. And yeah, they're just boxing clever, as it were, to make it as difficult as possible for the tenant to pursue the diversification. Yes, that's correct, in fact, because the case that I was describing established through a decision from the land court that the diversified activity has to be conducted by the tenant. Now, the land court didn't look at the pretty common situation where the tenancy is held by an individual, but actually the farming business is conducted via a farming family partnership of some sort, which is a very, very common scenario, and I'm sure you all know. Now, the Land Court has said in a previous case, in a different context, that it saw no objection to the tenant conducting his or her business via a family farming partnership. It's likely, therefore, that the Land Court would take the same view about a diversified activity. But what we know for certain is that what the tenant can't do is set up a limited company so that the limited company can carry out the business, because that's something that you're just not able to do using the legislation. So you would need landlord consent in that instance. Not if you've gone through the diversification procedure. If you've gone down the formal diversification notice route and therefore your diversification is statutorily protected, if it's fantastically successful, so that the farming becomes the smaller part of the overall business, you're okay because you're protected by having followed the procedures. It's where you haven't done that that you can lead to circumstances where the tenancy is at risk. So, this is all in the context of agricultural tenancies. Agricultural tenancies are strictly regulated by statute. Series of acts, the Agricultural Holdings Scotland Act 1991, the Ag Holdings Act 2003, Land Reform Act 2016 and so on. But for the purposes of being an agricultural tenancy, you've got to be carrying on an agricultural business activity, and that's what qualifies the agricultural lease for protection under the Acts. And therefore, a diversification is something which isn't an agricultural activity. So it's almost a definition in the negative. So if it's not an agricultural activity, it's a diversification, and that's what you need to get protection for. So that's a very interesting question, and I think the question this morning was in the context of planning legislation and agricultural support arrangements and so on. If you define agritourism activity as agricultural activity, then I think you would also need to amend the definition of agriculture and the Agricultural Holdings Act, which would be quite a complicated business. In one view, it cures all the problems about diversification overnight, because you just say, well, actually, it's an agricultural activity. So, but that, I think, seems to me at least, to cut across the interests of landlords who, at the end of the day, have let out farms. We now have a diversified procedure, but it is a procedure. It involves notice. It gives the landlord the rights to object and so on. So if we just defined agritourism as agriculture, there's no need for diversification at all. So I think it's unlikely that would be a consequence of agritourism activities being defined as agricultural activities. We'd still have the Ag Holdings legislation to contend with.
Any other questions? Just kind of following on, yesterday we had actually a lot of what we've been talking about at the conference has all been around relationships. I think it's been really key that everyone in the community has a good relationship, we work well and collaborate with industry professionals and each other. And we had a lovely comment yesterday we were talking about obviously the procedure that's really important to have at the stage when you're looking to go forward with diversification. And a couple at the front have said actually we've got a fantastic relationship with our estate. We're in really great common conversations, and they have a contact to go ahead verbally with all the things we can do, which is now invested a lot of money in. Everyone is very happy, and they were saying that we actually need to have this, and we've already got a great relationship. So you made a great point yesterday that yes, it's great that you've got that relationship, but at the end of the day, it could change. They'll have maybe the estate may be sold, or you have new management, or the next layers come through and decide to take their business in completely different ways. So I think that was a really good point. As much as relationships are really important to have, but when it does come to something like this, it's really important, as you said, is to follow that procedure and have it in writing. That was a great place to be. Another thing I wanted to bring up was a point that actually we raised for our business. We went through the procedure, we have the bit of consent, but part of the estate put a condition on it that they want us to return the land back to agricultural use if we leave. And they also, by doing that, we would not be given any compensation for anything we've done, so it would not be in our tenant improvements. That obviously goes against what you were mentioning, that actually we could do compensation. So I wonder how that stands, because it's written down, does that actually forfeit what you were saying? And also a little bit about the written word, the verbal contract as well. It's been said there's been a verbal discussion. So this part in that's something binding and law that was in the verbal agreement, because that was probably the previous one, does that still count?
So a couple of issues there, Kay. First of all, just an observation that there's nothing like a change of factor on a landed estate to provide an uptick in instructions across my desk. But leaving that aside, it's always better to have something either formal through diversification procedure or in black and white by agreement to protect against generational change. There might be a huge well of goodwill between the existing landlord and the tenant, and things will work perfectly well as long as those particular individuals are landlord and tenant. But it's the generational change which will often cause the problem. In relation to the question about compensation, if there's a diversified, you've gone through the diversification procedure, the landlord has come back and said, okay, I will agree to that, but I'm going to impose these conditions on it, then I think potentially at least, having thought about this a wee bit overnight, Kate, I think by accepting the condition to return the land to agricultural purposes, you've probably removed the ability to claim compensation for it. Having said that, thinking about it in the real world, if you've established a successful diversified activity, then if for whatever reason the tenancy was coming to an end and there's an economic activity of value there, one would imagine that there's scope for some sort of negotiated deal with the landlord, whereby the landlord is able to take over that activity. And if they're doing that, then that would have to be on the basis that compensation of some sort is paid. So I think take advice whenever the need arises. But I'm pleased to hear about that example in the real world.
Well, thank you very much, everybody, for coming today. I hope that's been really informative. We've had some really great questions, actually, from a very small group, and it's been very useful, so thank you very much.